Well, the Wisconsin Institute for Law and Liberty, a conservative legal group, filed a new complaint with the U.S. Department of Transportation exposing 4 states, including New York, that are trying to get around the Trump administration's ban on race-based DEI contracting in highway projects. I want to welcome Lauren Greuel to the show. She's Associate Counsel with the Wisconsin Institute for Law and Liberty. Lauren, good morning. How are you?
Good morning, Dave. I'm great. How are you?
Well, when I first heard about this, I thought I want to hear more. So break this down for us. What's happening here?
Yeah, so the Wisconsin Institute for Law and Liberty filed a Title VI civil rights complaint with the U.S. Department of Transportation on behalf of contractors for equal opportunity because 4 states, including New York, have continued their discriminatory minority business enterprise programs despite being in violation of Title VI and the USDOT interim final rule removing such race-based classification. So in New York, the State Department of Transportation put out a notice that it will be accepting competitive bids for public work projects. And this notice included at least 3 projects where a percentage of the contract dollars are supposed to go to certified firms in the minority-owned business enterprise program. In other words, the state is pressuring bidders to make subcontracting decisions on the basis of race in order to be awarded a public contract. So the New York State Department of Transportation is saying that the color of someone's skin is more important than the quality of their work.
Okay, where do we go with this information? What's going to transpire at this point?
Yeah, so we're asking the U.S. Department of Transportation to investigate these several state Department of Transportations. That's New York, Massachusetts, Maryland, and Indiana. And these 4 DOTs seem to be under the impression that they can do this because they're only using state funds for those projects, but that's incorrect. Many of these projects are to repair federal highways, bridges, tunnels, and they receive billions of dollars from the USDOT a year. New York State, for example, receives about $6.9 billion, that's billion with a B, from the U.S. Department of Transportation every year. So they're beholden to Title VI, and that's why we're asking the USDOT to conduct an investigation and tell them to stop these discriminatory practices.
Lauren, any idea how this information came to light?
Yeah, I mean, this is something that Will has been tracking for a very long time. We were involved in a lawsuit back in 2024. It was called Mid-America Milling Company versus the U.S. Department of Transportation. And it was actually the catalyst for the change to this federal rule. So back in October of 2025, the U.S. Department of Transportation published this final rule removing all of these race and sex-based presumptions from what's called the Federal Disadvantaged Business Enterprise Program. So prior to this, the DBE, which this federal program, included a rebuttable presumption that certain racial and ethnic groups were socially and economically disadvantaged. So in other words, if you were a member of these racial groups, the government would automatically assume that you're disadvantaged for purposes of DBE certification unless someone proved otherwise. And we sued over it because, again, the government shouldn't be presuming whether or not somebody's work or the quality of their work is affected by their sex or by their race. It all has to do with the individual person, and we've been fighting for this equality under the law for many years now. So this all came up as kind of precipitous from that lawsuit.
All right, Lauren, keep us in the loop on this. We appreciate your time this morning. That's Lauren Greuel, Associate Counsel with the Wisconsin Institute for Law and Liberty.